Welcome to today's webinar. Today's webinar is in relation to corporate insolvency and two topics in particular, insolvent trading and director penalty notices. A general message that while every effort has been made to provide valuable, useful information in this presentation, this firm and any related suppliers or associated companies accept no responsibility or any form of liability from reliance or use upon its contents. Any suggestions should be considered carefully within your own particular circumstances, as they are intended as general information only. So welcome, I am Louisa Sijabat. I am a registered liquidator and a registered trustee in bankruptcy. My contact details are there in case you have any questions about the presentation or your situation generally. Today, we'll be looking at what is insolvent trading, advising directors in relation to insolvent trading, and very briefly looking at ATO director penalty notices. Just a heads up in case you're tracking time as I go through, the great majority of today's webinar is on the first two parts, what is insolvent trading and advising directors in relation to insolvent trading. And it's just a brief 5-minute segment about ATO director penalty notices at the end. So there's no need to be concerned if quite a bit of the time has passed and we're still on the earlier parts of the webinar. So what is insolvent trading? A company is insolvent if it's unable to pay its debts as and when they become due and payable. Now, during this presentation, I'll reference certain sections of the relevant acts or anything that's relevant so that this presentation can be used as a further reference as well, but I may not necessarily read all of them out. A company being insolvent is different to a temporary lack of cash or liquidity. Directors have a duty to prevent insolvent trading by their company. This duty applies if a person is a director of a company at the time when the company incurs a debt, the company is insolvent at that time or becomes insolvent by incurring that debt, and at that time there are reasonable grounds for suspecting that the company is insolvent or would become insolvent. Insolvent trading is usually a civil penalty provision, but if the director's failure to prevent the company from trading whilst insolvent is dishonest, it can be an offence. So what is insolvent trading? Insolvent trading includes, as a definition of a director, shadow and de facto directors of a company. Insolvent trading, there is a contravention to insolvent trading if the director is aware at the time there are such grounds for so suspecting, and a reasonable person in a like position in a company, in the company's circumstances, would be so aware. So this is both a subjective test and an objective test as to whether a director contravenes the insolvent trading provisions in the Corporations Act. If there is a contravention, the company can recover from the director an amount equal to the loss or damage. The director does have some defences against insolvent trading, and these include the statutory defences, which are that the director had reasonable grounds to expect that the company was solvent at the time that the debt was incurred, that the director believed the company to be solvent based on the information provided by another person, if the director is ill at the time the debts are incurred, or it is proved that the director is not taking part in the management of the company because of illness or some other good reason, and the director can prove he, she, they took all reasonable steps to prevent the company from incurring the debt or debts. Insolvent trading is a legal action undertaken by the company's liquidator against a director or directors of the company. It can be undertaken by a creditor with the consent of a liquidator, or it can be undertaken by a holding. It can be undertaken against a holding company, which may be held liable for insolvent trading by a subsidiary company. So, is a company insolvent? How do we actually know, especially for advising directors, what should they be looking for to work out if their company might even be insolvent, or whether it's just experiencing a temporary lack of liquidity or cash flow? So there was a court case a few years back which set out a number of indicators of insolvency. Now remember, the overall test for insolvency is that a company is insolvent if it cannot pay its debts as and when they are due and payable. And these following factors are indicators towards whether that is true or not. So looking up these factors, they include continuing trading losses, liquidity ratios below 1, that is where the current assets of a company are less than the current liabilities of a company. So current assets are assets that are due to become cash within 12 months, and they're recorded on the balance sheet as current assets. Current liabilities are debts that need to be due and paid, debts that are due and due to be paid within 12 months. So that's what the liquidity ratio measures. If there's less current assets than current liabilities, then there is likely to be a liquidity problem, cash flow problem, and potentially insolvency problem in this company. Also, if there are overdue Commonwealth and state taxes, a poor relationship with the present bank of the company, including the inability to borrow further funds, no access to alternative finance, an inability to raise further equity capital, suppliers placing the company on COD, which is cash on demand payment, or otherwise demanding special payments before resuming supply, creditors unpaid outside trading terms, the issuing of post-dated checks, dishonored checks, special payment arrangements with selected creditors, solicitors' letters, summonses, judgments, or warrants issued against the company, typically for unpaid debts, payments to creditors of rounded sums which are not reconcilable to specific invoices, and the inability to produce timely and accurate financial information in relation to the company's trading performance and financial position. Now, coming back to the point, which is payments to creditors of rounded sums, the reason this is a potential indicator of insolvency is sometimes creditors will have a whole statement of unpaid invoices. And in order to induce further supply, the creditor might say, look, if you pay me $1,000 a week, we'll continue to release stock to you. Or if you pay the last 3 invoices, we'll continue to release stock. So the invoices might be uneven amounts, but it's indicative of some sort of payment arrangement. So Asic Regulatory Guide RG 217 sets out more factors. These are very similar to the ones before, but they do include some different ones, including difficulty selling stock or collecting debts owed to it. I've included these here as a reference so that this presentation or this slide can be used as a reference in the future, but they're very similar to the ones before, so I won't read them all. So overall, the point is to look at the situation holistically. And the golden question is, can the company pay its debts as and when they become due and payable? And the last few slides are about the factors that point towards an answer to this question. So we'll now turn our mind to advising directors. If we are advising directors as to whether their company is trading insolvent or not, how they can progress to the next steps in the best possible way. So once insolvency is suspected, directors should take positive steps towards developing a course of action for the company that is reasonably likely to lead to a better outcome, or alternatively, immediately appointing an administrator or liquidator to the company. To decide the above, the director may be required to properly inform themselves of the company's financial position, take measures to ensure the company is keeping appropriate financial and business records, obtaining advice from one or more appropriately qualified entities regarding the company's solvency, restructuring options, financial position, and legal exposure. In particular, directors should look to obtain advice which considers the potential courses of action and compares them with the result that follows from the immediate appointment of an administrator or liquidator. So in short, what that means is advice saying, if you were to liquidate or put the company into voluntary administration now, this is the forecast outcome. This is an alternative that might result in a better outcome to creditors and stakeholders than the immediate liquidation or administration of the company. So that can be quite technical. It's got some quite intuitive elements, but it can be quite technical as well. But it is very important for directors to be well informed and well advised. Directors should also assess whether the company will continue to be in a position to meet all payments as and when they become due and payable, and assess whether there may be any employee fraud, theft, or other misconduct, and if so, address it immediately. The specific reason for that particular item will become relevant very shortly. So in layman's language, I would say please don't ignore the situation or do nothing. Even if it's stressful for the directors to think about, it can actually get worse. There are a number of directors who turn up and say this couldn't possibly get worse. And unfortunately, the answer is it actually can. So it's better to do something proactive to make the best of the situation rather than just ignore it. I've never seen a situation improve in this area without intentional action towards improving it. What are the options available in this company-specific situation? It's important for the directors to find out information about the options available to them and then work out which option or options are likely to be best. I always recommend having a plan and a backup plan because, as we know, not all plans go to plan. It's a little bit prepare for the worst and hope for the best. And just speaking with a liquidator or administrator doesn't mean they have to go down that path. I highly recommend looking at the situation holistically for the company itself as well as for the directors. Now, sometimes their interests will be aligned, but sometimes they may not be, and sometimes separate advice is required for the company and for the directors. What does Asic say directors should do if they think their company could be trading insolvently? So Asic Regulatory Guide 217 says directors should actively monitor the solvency of the company, investigate financial difficulties, obtain advice from an appropriately qualified person where necessary, and consider and act appropriately on that advice in a timely manner, which essentially summarizes the points we've talked about before. How concerned are directors about insolvent trading? So in my experience, directors or boards of larger companies tend to be more concerned about insolvent trading than directors of smaller companies. Larger companies, on average, tend to have better governance structures and may have a directors and officers or D&O insurance policy, which may or may not cover insolvent trading. While SME businesses, in contrast, may primarily be concerned with not losing their family home, how they make mortgage payments, how they pay their employees, and other such issues. However, regardless of how concerned directors may be in relation to insolvent trading, it applies to directors of all companies, regardless of size. So what are the options available to directors? Firstly, there are informal restructuring options. Now, this is contrasted with formal restructuring options, which sometimes are done together, like in a complementary way. But let's have a look at what we call some informal restructuring options first. So the reason they're called informal is because they're generally not announced to the market or made public. And this is even if the company is an ASX listed company, there are certain things that can be undertaken without having to make a market announcement. Informal restructuring is aimed at making significant changes in the business to return it to profitability and growth. These can include things like strategic planning, refinancing existing banking and finance facilities, recapitalizing the business, including through new investors, sale of all or parts of the business, especially non-core parts of the business, consideration of strategic acquisitions, management and personnel changes, market repositioning, cash flow planning and negotiations, and operational improvements. I've listed some below as ideas, again, so this can be a reference. So formal restructuring of a company is publicly known. It enables certain actions to be taken that aren't available in an informal restructure or can be approached more optimally for the company or group. This is usually through a voluntary administration and deed of company arrangement structure. This can include things like exiting some leased premises while retaining and continue to trade from only profitable locations. This is so you don't have your unprofitable locations cross-subsidizing and draining the profit out of your profitable locations. Changing the mix of larger and smaller store formats. Exiting certain businesses of the company or group while retaining others. That's especially for large groups that have multiple different types of businesses. This also includes a formal process for employee terminations and redundancies or redeployments if needed, especially for exited locations and exited businesses within a company or group while you're retaining others, so partial workforce redundancies, not whole workforce redundancies. Dealing with all legacy debts that aren't secured against assets from before the date the formal restructure starts altogether, rather than negotiating payment plans and arrangements separately with each party, which saves valuable management time and energy to focus on the future of the company. So a successful deed of company arrangement will bind all unsecured creditors of the company, as long as sufficient creditors vote for it, but it doesn't need to be 100% of all creditors voting for it. Terminating selected supplier, overhead, or operational contracts and expenses while retaining others to free up cash flow, and essentially right-sizing the business to optimize it for future profitability, growth, and agility. Also, there is a liquidation option where there are a couple of things that could happen with the business in a liquidation. So sometimes the directors wish to continue operating the business, but they don't want to trade whilst insolvent. And sometimes they're just over this business altogether and would like to close it down for good. And sometimes they'll say to me, I just want to go work for somebody else for a little bit and not have to be a business owner or director. Now, I'll address the second point first. A liquidation can definitely close down a business to the point where it's no longer operated by anybody at all. It's an orderly close down, which is definitely better than the alternative, which is a disorderly close down or abandonment of the business. Now, if the directors wish to continue the business, there's something they need to be aware of, which is this concept called illegal phoenixing. So illegal phoenixing is sometimes also known as asset stripping a company, where certain assets might be taken out of the company with all the debt left in the company, and then the company put into liquidation. Now that's illegal, so definitely not recommended. And it's important that if the directors are doing some sort of restructure where the business continues, that it is done properly and legally. So there is a way to do it properly and legally. For example, a new company may wish to buy at market value the assets of the business or the business itself. Now, what's the market value of the business or the assets itself? This might be determined by a registered independent valuer with a specialization in whatever type of assets are sought to be bought. This is as if they were going to be sold to a third party, but are instead sold to a related party. It is important that the directors do the right thing by the old company and make sure it receives market value for any assets that are sold or transferred out of the business if a new company is wishing to acquire those assets or that business. So, looking at this situation holistically, another important question before liquidation is what has the director personally guaranteed or will become liable for on the liquidation of the company if not already? So, personally guaranteed debts are debts that the director has said that he or she or they will pay personally if the company, who might be the primary creditor, fails to pay them. Now, sometimes directors are very well aware of what they've personally guaranteed, but in a number of situations, I have seen that they are not so aware. So typically, things to think about in terms of personal guarantees or potential personal guarantees are the company's banking facilities. There's often a personal guarantee side for them. The company's other financing facilities, any equipment, motor vehicle, or other lender finance, some supplier accounts perhaps, and sometimes the ATO. Now with the ATO, whilst technically the director can choose to personally guarantee it sometimes the ATO can deem the director as having personally guaranteed the amounts, but we'll come to that later because the last topic of this webinar is director penalty notices, where I talk about that a little bit more. Now, when most people are thinking about insolvent trading, sometimes they've heard this phrase safe harbor being discussed. So what is safe harbor and how is it relevant in relation to insolvent trading? So, safe harbor is protection for directors from a civil insolvent trading claim liability in certain circumstances if their company later enters liquidation. Section 588GA subsection 1 of the Corporations Act excludes liability for insolvent trading if, at a particular time after a person starts to suspect a company may become or may be insolvent, he or she starts developing one or more courses of action that are reasonably likely to lead to a better outcome for the company, and the debt is incurred directly or indirectly in connection with that course of action and during a specified time period. So in summary, the aim is to encourage directors to take action and reasonable risks to return their companies to being profitable, cash flow positive, and so on, without fear of an insolvent trading claim against them if they're unsuccessful and their company ultimately ends up in liquidation. Directors still have a duty to consider the company's interests before their own in this situation. So to access safe harbor, there are a number of steps that it's recommended that directors work through in relation to their companies. These are a summary of those steps. Firstly, to check that any outstanding employee entitlements are paid and ensure that the company will be able to continue to pay employee entitlements by the time they fall due. To check that the company is meeting all of its tax reporting obligations and to ensure that systems are put in place to enable the company to continue to meet those obligations. To check that there are no outstanding issues relating to misconduct of employees and officers that need to be resolved. Directors should focus on ensuring employees are complying with company policies, and misconduct should be identified and dealt with appropriately. Checking existing insurance and indemnity policies, including any directors and officers insurance, is up to date and adequate, and any notification requirements for those insurance policies. Before incurring any further company debt, consider making an initial assessment of whether it will lead to a better outcome for the company or compared to an immediate appointment of an administrator or liquidator. At this stage, directors should consider obtaining advice from an appropriately qualified entity and ensure that that entity was given all of the relevant information required to provide advice regarding the company's prospects. If the initial assessment and advice points to the likelihood of a better outcome for the company than the immediate appointment of an administrator or liquidator, the directors should consider developing a restructuring plan in earnest. Directors should consider making arrangements also to ensure that relevant documents are recorded carefully and archived. To consider placing the following items on the agenda of the board as standing items for consideration and discussion in an ongoing manner. The adequacy of financial records and how these records might be improved, the financial position of the company and whether it has deteriorated or improved and how this might impact the availability of safe harbor to the directors, whether further advice needs to be obtained from an appropriately qualified entity, whether the restructuring plan is being implemented, and whether adjustments will be required to ensure that the desired outcome will be achieved, and whether, all things considered, it would be better for the company to immediately appoint an administrator or liquidator. So, in summary, this is an ongoing monitoring task. It's not a set and forget to access safe harbor. It is something that needs to be ongoing. So once the restructuring plan is developed and implemented, the directors need to make sure that it is continually considered a better option than the immediate liquidation or administration of the company. When implementing the restructuring plan, I've jumped ahead then. When implementing a restructuring plan, the directors should continually assess whether their chosen course of action will still lead to a better outcome for the company to pursue the restructure when compared with the immediate appointment of an administrator or liquidator. When necessary, directors should obtain new advice from an appropriately qualified professional regarding these steps. If the company is placed into formal insolvency, the directors should ensure compliance with any obligations relating to the provision of books and information to a liquidator, administrator, or controller. In addition, directors should ensure they are compliant with their obligations to provide assistance to the liquidator, administrator, or controller. Now, all of those steps are required in order for a director to access safe harbor. That is, some sort of prevention against an insolvent trading claim for certain expenses incurred in connection with the safe harbor restructuring plan. Now, just say, for example, the director does all the steps but decides not to cooperate with the liquidator at the end, they still can't access safe harbor because that is one of the required steps. So, a few key things about safe harbor. Timing is important. Safe harbor only starts after developing one or more courses of action reasonably likely to lead to a better outcome for the company than the immediate appointment of an administrator or liquidator. It is recommended that directors move promptly to implement action, but suggests that directors are protected from the development stage of the plan. It may be worth considering if new debt can be delayed or deferred until a company is in safe harbor, so that is covered by the safe harbor as well. And due to the extent of professional advice and all costs involved, it's most commonly directors of larger companies who investigate and access safe harbor, but there's no restriction in the legislation and it is available to all company directors. Now, a very brief note on ATO director penalty notices. So firstly, what is a director penalty notice? It is a notice issued by the ATO to recover the company's unpaid taxation liabilities from the director personally. So this is a separation. There's usually a separation between the company as a legal entity and the director as an individual or person recognized by law. But if a director penalty notice is issued by the ATO, there is no longer that separation and the ATO seeks to recover the company's unpaid taxation liabilities from the director personally. So is liability automatic on the issue of a DPN to a director? It depends on when the PAYG withholding and GST payable was reported to the ATO. In summary, if the unpaid PAYG withholding or net GST is reported within 3 months of the due date, a director can resolve the DPN by paying it in full, which realistically is usually not a very viable option at that point, because if they could have paid it or if the company could have paid it, it usually would have been paid by then. But there's another option for resolving the DPN in full, which is to either put the company to voluntary administration, liquidation, or a small business restructure. All are usually required to be done within 21 days of the date of the DPN. However, if the unpaid PAYG withholding or net GST is reported more than 3 months from the due date or unreported, a director can only resolve a DPN by paying it in full. So you'll notice the big difference there. If it's reported within 3 months of the due date, you can put the company into voluntary administration, liquidation, or small business restructuring as an alternative to paying it in full. And that resolves the director's requirements under the DPN fully. So the outcome of this, or the takeaway point from this, would be even if the company can't pay its PAYG withholding or net GST when it's due, it is highly recommended to lodge the BAS or the reporting statement on time or within 3 months of its due date, so that if the ATO come back and seek to issue a director penalty notice to the director has a way to resolve it fully, which includes options other than having to pay it in full personally. Now, in relation to superannuation, unpaid superannuation has to be reported by the due date in order for a DPN to be able to be resolved in full by either payment or putting the company into voluntary administration, liquidation, or small business restructuring, all usually required within 21 days of the date of the DPN. If unpaid superannuation is reported late or unreported altogether, the director can only resolve the DPN by paying it in full, which is quite a different consequence, as we've just mentioned. So, what's been happening lately with the ATO and DPNs, and why have we decided to discuss this topic now? So, on the 13th of May 2022, so relatively recently, the ATO issued a press release on its current approach to debt collection. In summary, in this press release, it said that the ATO wants taxpayers to engage with the ATO, that is, respond to calls, set up a payment plan, and engage with the fact that there is a tax debt. If not, the ATO is now, quote, taking firmer actions. These include garnishes, recovery of director penalties, disclosure of business tax debts, and legal actions including summonses, creditors petition, wind-up, and insolvency action. Close quote. Now, this is quite an unusual statement for the ATO to make. I've not historically seen the ATO put out a press release in relation to its debt collection and be so specific about the firmer actions it's intending to take. So a garnishee is when money can be just taken from a company's bank account after the ATO has done certain legal processes on its side or issued certain notices on its side. But from a company's point of view, the director or accountant typically wakes up one morning and the money, it can be tens or hundreds of thousands of dollars, that was there is now not. So the companies do not get a warning ahead of time, and that is usually totally legal. It's usually a most horrible shock for the company that its very important and sometimes scarce funds are now gone. Recovery of director penalties. We've talked about director penalty notices a little bit. Disclosure of business tax debts. This is where, in certain circumstances, for business ATO debt over $100,000 and certain other criteria to be met, the ATO can now disclose to credit reporting agencies that this debt exists. This, of course, impacts others that provide credit to the company and may affect in them changing the payment terms with that company, or perhaps not extending them credit or reducing credit, which is all important to companies' cash flow when it's already having difficulty paying its debts. Legal actions are somewhat self-explanatory. Summonses, creditors petition. A creditor's petition is a step towards somebody's bankruptcy. A wind-up is a step towards a company's liquidation. Insolvency action just is a more general term for those actions. So the ATO also said they are starting with larger debts as well as superannuation debts of any size. The ATO has sent 52,000 director penalty notice warning letters. These are not actual director penalty notices, but they are issuing director penalty notices at 30 to 40 a day, and specifically wrote that they expect this to increase. The ATO has also issued 29,000 warning letters to businesses of potential disclosure to credit reporting bureaus, which they can do for ATO business debt over $100,000, especially when there's non-engagement from the taxpayer. Now, they've also pointed out that these are what they call orange letters and not blue letters. That is, the headline on the letter is in orange, which to them is a more severe or urgent warning to the taxpayer that they ought not to ignore the letter. Standard reminder notices tend to come out with a blue headline, and so the ATO are impressing upon taxpayers the urgency and importance of these letters and not doing nothing when they are received. So what do you do if you or your client gets an ATO orange letter? If your client can pay, the first step would be to set up a payment plan with the ATO ASAP, as soon as possible. That's the engagement the ATO is looking for at this stage. If your client can't pay the tax debt, please speak with me or someone like me about what options the client has and which one-on-ones are best in their situation. Please advise them not to do nothing, though. They don't want to end up personally liable for their company's tax debts. It's not worth it. Now, I'll just have a check to see if there's any questions. There don't seem to be any questions. And if so, given that, thank you very much for attending, and I hope it's been informative and useful to you.